succeeded in the petition, and he ended up joining government or having a handshake for purposes of Kenya. For purposes of Kenya, he did an handshake for continuity because the economy was not been doing well for the longest time. So for purposes of Kenya, he actually was able to do an handshake. And then he's again in 2022 in court. If we can quote him today, he said, "It's not about me. It's about fostering democracy, which is if there is anything we can credit the man is that he's a democratic Kenyan and he's actually a person who is out for the good of Kenya, and that in itself embodies a man who has done much more than any other president, because nobody has been able, amongst the presidents who have led Kenya, you've not seen anybody stand strongly for Kenya. Some of them have been elected, but I'm sorry to say, nobody has been able to be for Kenyans. Raila represents the common man and the interests of the people. They have done their bit in terms of developing the economy or trying to do their single political issues around leadership, but in a uniform scale, I think if you get to put them on a weighing scale, I think he really weighs way much more than any other president in terms of fostering democracy.
Now, Gisore, thank you for that in regard to, how we have covered. And we have seen quite sensational headlines, as you said there, but we need to remain factual. As your colleague there has given us a 7 out of 10, giving us room for improvement. Indeed, we will work on that. But now let's find out what is happening within the central business districts. Statistics indicate that 85% of workstations are domiciled within the CBD. Now, being September the 5th, we are joined by Hibak Sayed from Kencom there. We can say it's the center of CBD, to just bring us up to speed with what is happening as Kenyans await that particular ruling. Hibak, hi, how are things from Kencom?
Thank you, Regina Manyara. We are at the Central Business District and we're just trying to gauge what exactly is happening, especially here at the capital of Kenya, Nairobi City. We have a few people, a few businessmen, boda riders, who are just trying to get their daily means as we wait for the Supreme Court ruling. A few minutes to 12. If you could just have your opinion, sir, on what exactly you've seen. The Supreme Court is about to give a very important judgment today. Unaona vipi biashara yako imekuwa vipi na umeonaje town iko leo?
Let me start by saying that my name is Dudhiman. I'm the CEO of Dudhiman Show, and I'm so much glad and happy to have this opportunity with you guys. God bless you so much for doing an amazing job. Now, let me start by saying that we are okay in town, we are operating, we are doing something so amazing. And to make the matters worse, our border riders here in Besni CBD are doing quite excellent job. I have a good friend of mine who is the national coordinator for border riders here in Nairobi, and we are happy for it. We are happy. So we are waiting to see. We doesn't know what is going to happen. We doesn't know what Kome is going to say, but we are happy because my brother is your brother. Your sister is my brother. We doesn't want to know the ethnicity. We doesn't want to know where you come from. Your sister, your brother. But we live like brothers and sisters. Despite having anything or doesn't have anything, we share the little that we have. So as a border rider who is a journalist by profession, because I've worked with your media or whatever, I'm happy, we are happy. So let me just give a take to my brother and say something.
Just to cut you off, Regina, we've been checking around and we've seen that the shops are mostly open, the businesses are functioning quite well, people are conducting their business as they always have. As you can see, we're at Kencom, and most of the matatus are carrying people just as they always do. People are waiting, yes, for the ruling by the Supreme Court, but people are going about their business here in Nairobi City. If maybe we could have the opinion of a Kenyan, unaonaje kuhusu hii Supreme Court ruling, unaonaje, nini unatarajia?
Okay, kwa majina ni Victor Chiteri from Kibra. Enye ningependa tu kusema ni those results of the CJ has announced the results. Let us take as normal so that we can continue with our normal work, so that people can continue with their normal business. Thank you.
Well, I'm going to have to give it back to you, Regina. We're still going to be traversing Nairobi City, and maybe we'll go to another street within the Central Business District and to just see what exactly happens as the day progresses and as the judgment comes. Back to you, Studio Regina.
Thank you, Hibaka, for that quick update. I can see, yes, Kenyans quite the, still being Kenyans trying to make light of the situation, even as it remains, on tenterhooks. We remain on tenterhooks in regard to what we should expect come the next 6 minutes there. And we are live. We have our reporters there on ground, including Serafina Nairobi, who is going to be bringing us up to speed with what is happening. Kenyans asked to remain peaceful as we wait the 7-judge bench there to make a ruling in regard to the August presidential petition. What you're seeing on your screen, those are live pictures from Milimani there. We have seen various councils have arrived. We have Kithure Kindiki there, who is part of the Kenya Kwanza legal team. There is Katwa Kigen just crossing your screen there. Further ahead there, we are also having other councils who are have been representing the respondents or the petitioners there, all looking calm. At the end of the day, we have there has to be peace and justice going forward. We are all brothers and sisters there. Now, I want to hand it over, take it back to you, Troy, there. We were talking about the performance and the conduct of the media during the election, and even at the point where we are right now, focusing on the presidential petition. And from Hibak Said's link there, you can see there's a Kenyan there who has introduced himself as Nduthi Man. And what I am actually proud of is that during this particular election, we did not have an issue of, sensation, so to speak, with the Githeri man aspect and such. We did not see this. We kept it to matters of fact. And I would want to say, let's toot our own horn as media fraternity there. But it was a light moment to try and see that there was a gentleman behind Said Hibak there, calling guys to tell them, hey, you need to watch us. You need to watch us from KBC Channel 1. I'm live. Well, we also want to welcome your feedback. You can get us on Twitter on KBC Channel 1. But before we get to read what you have to say on Twitter and the expectations, we want to take you down to Kibra, where we're joined by my colleague Irene and Chuma Odim to bring us up to speed with how things are looking like in Kibera. Good afternoon.
Mama Mobutu, Marie Antoinette, his first wife, they were married, I believe, when she was 14 and he was 16. She was extremely influential. She was a very strong woman. Sometimes when I was seated with him, we'll be getting back to you. We are domiciled in various parts of the country just to keep tabs on what is happening as we await the much anticipated verdict on the presidential petition of August 2022 there. Security has been beefed up. A communication is made to Kenyans, especially who are operating within the central business district. Various roads were closed, including Gong Road at the junction of NHIF there, as well as, some motorists redirected not to use the Haile Selassie Avenue there to just try and keep crowds out of Milimani there, where the 7-judge bench is going to be giving its ruling, led by Chief Justice Martha Koome. What you're seeing is security outside Milimani Lowcourts there. That is a contingent of national police as well as a general service unit. And inside there we're seeing a council made up of, various, there we go, we have Soweto there. Council Soweto there. You can see how she's already there. I would want to know what's going on through the minds of the lawyers there, both for the petitioner and the various respondents there, who over the last 2 days have exuded confidence that they're going to be carrying their day, or rather their prayers are going to be carrying the day. In the next 1 minute, we are expecting the 7-judge bench there. We are seeing Feroz there, Luigi, as engaging Professor Githu Muigai and the legal counsel there, governor-elect, that is James Orengo. Quite camaraderie there, transpiring between the senior counsels there. So
as we say, it's all in a day. It's all in a day when it comes to, you know, matters of litigation, and that there are no permanent enemies. But we asked that Kenyans remain peaceful, and justice, we hope, is going to be served in this particular matter. Yes, that.
Size enough. Look at the pictures on your screen. James Orengo there, and other lawyers who are representing different factions. And they're all seated together, they make fun together, they argue it out, they sweat it out together, and maintain the peace. That is exactly what should be happening, not only in that court, but in the Republic as well. Before we crossed over to Irene, we were talking about how, despite the fact that he has had some hits and misses in presidential petition, is that he has been able to bolster our democracy in regards to electoral matters. And I would like to pick Shadrach's mind on the same, is despite that Raila has won and lost some of the petitions, he has actually helped the electoral system in the country. That was an interesting read. I was reading from a journalist as well. And on the 7 out of 10, yes, I do agree, because there are some journalists still talking about a ruling. We don't expect a ruling, we expect a judgment today, because it's the final product of what they have been hearing for the last couple of days. Wambui, I would like to pick your mind on the same.
Well, there is a lot to admire from the two gentlemen who have been, you know, entertaining us with this presidential dispute. And one thing you will give to Dr. William Samoei Ruto first is his spirit of resilience. That spirit of, you know, when he wants it, he goes for it. I mean, that is something admirable from his humble background. That is something that you will have to admire and acknowledge. On the other hand, you must acknowledge the kind of contribution that the Right Honorable Raila Amolo Odinga has given us as a country. So many things. I mean, the laws that we currently enjoy have you know, we actually enjoy them largely because of the contribution he has made, the kinds of pain he has had to go through. You know, you speak of the multi-party, us becoming a multi-party democracy in the year 1990s. I mean, that is his contribution. His fight against the Moi utilitarianism, I mean, that is his contribution. Most of us have studied to an extent, and we appreciate the jurisprudence that has been created by Right Honorable Raila Amolo Odinga. When you go to school, some of the things that lecturers teach is the jurisprudence that has emanated from the 2013 jurisprudence, which if Raila Amolo Odinga had not desired to go through that route, if he had not paid the security of cost of 1 million and paid the filing fees of 500,000 shillings, probably we will not have learned or gotten an opportunity to understand the law deeply the way we have understood it. Then, champions are actually made from people who try. Sometimes they fail, because if you do not try, there is no likelihood that you will ever succeed, you will fail. But his failure in the year 2013 did not in any event discourage him from trying our democracy through the court processes. So that in the year 2017, we saw him participate in the elections, we saw him challenge the elections, the election results, so that the win that he got in the year 2017, and of course his refusal to participate in the process because of the referee. So whatever the outcome that we will get, if it is a repeat of the elections, then it will be a gift to Right Honorable Raila Amolo Odinga, because we do not expect that he will be running in the year 2027. I mean, if age is anything to go by. In any event, even with probably a repeat of the process, it does not necessarily mean that it is a loss to Dr. William Samoei Ruto. No, it does not mean it. It only means that probably this is just but his dream that has been deferred, so that he will have another opportunity, probably in the next or within the 60 days that are set in law, and even probably even in the future, I mean, Right Honorable Dr. William Samoei Ruto is a young man who has a lot of life in himself. I think today he should be turning 55 years of age. Really, he has a lot. Yes.
Now, Wamboi, let's get to hear what is happening down in Kibra, where we're joined by Irene Mchuma Odim there to just bring us up to speed with what is going down there. Good afternoon, Mchuma. How are things at Kibera, or rather in Kibera?
Regina, good afternoon. We are coming to you live at Kianda area in Kibra constituency. Earlier on, we were at Ayani and Makina areas, and Regina would say it's business as usual to a huge number of residents here in Kibra constituency. However, there are those who are following the proceedings from their screens. This as we wait for the verdict of the Supreme Court. Remember, Raila Odinga, who is the Azimio La Umoja presidential candidate, is also the ODM party leader. And Kibra constituency has time and again given him a back wherever he's making a move politically. And interestingly, Regina, unlike what many people would anticipate, that many people will remain at home and not go back to the business, is business as usual for many residents here in Kibra constituency. In fact, the shopkeepers, the tailors, the welders are going on with their business as usual. The matatu operators, boda riders.
Thank you very much. The 7 judges making their way that are about to take their seats. Remember, these particular 7 judges are made up of William Oko, as you can see on your screen, flanked by Njoki Ndongo having a seat, Isaac Lenaola, Smokin Wanjala, Philomena Mwili, who's a Deputy Chief Justice, and Martha. Let's have a listen in.
Good afternoon and welcome to the Supreme Court of Kenya for the delivery of judgment in presidential election petition number E005 of 2022 as consolidated with E001, E002, E003, E004, E007 and E008 of 2022, Raila Amolo Odinga and 6 others versus William Ruto and 13 others. The Honorable Chief Justice and the President of the Supreme Court is presiding.
Thank you. Very good afternoon, ladies and gentlemen. Yes, this is the judgment of the court, which is delivered pursuant through 23(1) of the Supreme Court Presidential Election Petition Rules 2017 in the presidential election held on the 9th August 2022. This is an abridged version of the judgment. The full judgment will be delivered after 21 days. Kenya is a sovereign multi-party democratic state whose foundations are firmly spelled in the Constitution. The Kenyan people's quest for electoral reforms since independence is well documented. That notwithstanding, and even without going back to the pre-1992 era, every cycle of elections has been highly contested, with the exception of 2002. This speaks to a background of distrust of the administration of our electoral process. Informed by this setting, Kenyans made a decision to vest the Supreme Court with the jurisdiction to determine questions regarding the validity of a presidential election under Article 140 of the Constitution. The reactions following the declaration of results of the presidential election of 9th August 2022 shows that the Independent Electoral and Boundaries Commission, IEBC, has not yet garnered universal public confidence and trust in the internal management of the Commission and elections. On the 15th August 2022, 6 days after the general elections were held, Mr. Wafula Chebukati, the chairperson of IEBC, announced the following results. Raila Odinga, 6.942,930 votes, representing 48.85%. William Ruto, 7.176,141 votes, representing 50.49%. David Wahiga, 31,987, representing 0.23%. George Wajakoya, 61,969, representing 0.44%. Based on the aforesaid results, the chairperson of IEBC declared William Samoei Ruto the first respondent, the presidential candidate for the United Democratic Alliance Party, as the president-elect. This declaration has precipitated a total of 9 presidential petitions that are filed before us, to wit, number 1, presidential election number 001 of 2022, John Njoroge Kamau versus Wafula Chebukati and 3 others, and Raila Amolo Odinga and 7 others named as interested parties. The second petition is presidential election number 002 of 2022, Youth Advocacy Africa and another versus IEBC and 12 others. Third petition, presidential election petition number 003 of 2022, Kerif Khalifa and 3 others versus IEBC and 3 others. Fourth petition, presidential election petition number 4 of 2022, David Kariuki Ngari versus IEBC and 9 others. 5, presidential election petition number 5 of 2022, Raila Amolo Odinga and another versus IEBC. 6, presidential election petition number 6 of 2022 by Moses Kuria and others versus Honorable Raila Amolo Odinga and 4 others named as interested parties. Number 7, presidential election number 007 of 2022, Okia Omtata Okoiti and others versus IEBC and others. Number 8, petition number 008 of 2022, Julia Nyokabi Chege and others versus IEBC and 3 others. And the last one, but not least, petition number 009 of 2022, Ruben Kigame Richete versus IEBC and others. In addition to these petitions, we received a total of 24 interlocutory applications and 1 preliminary objection, which were filed in this court. 2 of the presidential election petitions were struck out. That is petition number 6006 and 009 of 2022 for failure to meet the constitutional threshold as set out under .004, 005, 007, and 8, the responses and the submissions filed thereto, this court found that all the 7 petitions substantially raised similar issues and sought similar reliefs. Consequently, on 30th August 2022, this court ordered that the 7 petitions be consolidated and designated Presidential Election Petition number 005 of 2022 as the read file. From the consolidated petition, the responses filed and submissions filed by all the parties, the court crystallized the following issues for determination. And those issues are there. We have repeated them several times. I will not read them. Having considered and deliberated upon the consolidated petition, the attendant responses, submissions, and also considering the amici curiae briefs, we now make the following determination on issue number 1, which is whether the technology deployed by IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. As noted in the introduction, lack of trust in the electoral system has endured in Kenya for a long time. This led to the introduction of electoral technology following recommendations made by the Independent Review Commission on the general elections held on the 27th December 2007, popularly known as the Kriegler Commission report. That report recommended integration of technology into Kenya's electoral process for registration, identification of voters, and transmission of results. These were enacted in Section 44 of the Elections Act 2011. By this statute, IEBC is enjoined to adopt technology in the electoral process. As a consequence, the IEBC developed a technology known as Kenya Integrated Electoral Management System, KIEMS, making Kenya's election process an hybrid as it employed both technology and manual processes. The first, third, and fourth petitioners in the consolidated petition challenge the technology used by IEBC during the 2022 general election. They plead that the manner in which technology was deployed and utilized fell short of the prescribed constitutional and statutory standards. As regards the audit of the register of voters, they urge that IEBC, pursuant to its elections operations plan, committed itself to conducting an audit of the register of voters by 31st March 2022. To the contrary, they arrange it only publicly availed the audit report on its website on 2nd August 2022, which was only 7 days to the elections. In this report, it was noted that the auditors established serious gaps and risk to the electoral process, including numerous cases of change of voter stations without knowledge or approval of the affected voters. Grant of voter update privileges in IEBC, IDMs, to 14 user accounts and related to voter registration. Reducing the accountability of user activities in the register of voters. Presence of 11 active generic accounts on the AMBIS application and the 2 MBIS users with the same logging identification, risking unauthorized system users, possible interference, change of particulars or deactivation of voters in the system, IMBC's failure to set up access, decertification, and user activity review process. And IMBC was also arranged to have failed to respond to requests by auditors for crucial information. On the integrity of the technology deployed, it was the case for the 7th petitioner that in order to comply with Article 86 of the Constitution and Section 44 of the Elections Act, the technology deployed must be simple, accurate, verifiable, secure, accountable, and transparent. On the simplicity of technology, the 7th petitioner contends that the KIMS kit failed the tests as they were not easily usable by ordinary citizens without expert knowledge. They further assert that IMBC was expected to procure and put in place a technology necessary for the conduct of the general election at least 120 days before the election and ensure consultation with the relevant agencies, institutions, and stakeholders. Furthermore, the petitioners arranged that IMBC violated its constitutional duty by delegating the design, implementation, and conduct of the KIMS components of the election to a foreign company, Smartmatic International Holdings, BV. As a result, IMBC staff and the public did not have full comprehension of the KIMS components. They conclude, therefore, that IMBC abdicated and surrendered its role to conduct elections to Smartmatic, and that IMBC vigorously fought any attempt to subject Smartmatic's activities to accountability and transparency, including the safeguards required by Regulations 61, 69, and 75 of the Elections General Regulations 2012. In response, IMBC has submitted that the electoral system met the constitutional threshold, that all the necessary information was accessed only by the authorized persons. The information was accurate, complete, and protected from malicious modification, either by authorized or unauthorized persons. IMBC maintained an audit trail on activities related to information, and that the information was available and could be authenticated through the use of various security features. In further response, IMBC contended that they engaged KPMG on 7th April 2022 to conduct an audit of the register of voters, which was submitted on 18th June 2022. In addition, it issued a briefing on the report on 20th June 2022, summarizing the thematic areas therein and disclosing its findings as well as actions taken to remedy the issues identified. It also conducted its annual audit in compliance with Regulations 11 and 12 of the Election Technology Regulations 2017 and a certification of compliance issued to it on 3rd August 2022. IMBC relied on sworn affidavits by Michael Ouma, Moses Sunkuri, and Hussein Majan on 26 August 2022, which were to the effect that it published the interim report by KPMG on 8 June 2022 and embarked on remedial measures aimed at effecting the recommendations ahead of publication of the final report. It was ascertained that it could not publish the full final audit report, as doing so would compromise the integrity and security of the electoral technology system, considering the provisions of the Data Protection Act, which imposes a duty to protect the data of Kenyan voters. On the other hand, the first and second respondents urged that even if there was failure of technology, it did not vitiate the result of the presidential election. Upon considering all the printing submissions and the ICT scrutiny and inspection tallying and recount report, which fully examined the IEBC's result transmission system, RTS, we are not persuaded by the allegation that the technology deployed by IEBC failed the standard of Article 86A of the Constitution on integrity, verifiability, security, and transparency for the following reasons. 1, whereas it is true that the KIMS kit failed in 235 polling stations, 86,889 voters were granted the right to vote manually, and the requisite forms 32A were duly filed. This happened successfully in Kibwezi West constituency and parts of Kakamega County. 2, while the audit report was released to the public 7 days before the 9th August election, the register of voters was used at the election without any apparent anomalies. 3, Smartmatic was procured to provide the necessary technological infrastructure, as IEBC did not have the capacity to do so. No credible evidence meeting the requisite standard of proof of access to the system by unauthorized persons was adduced by the petitioners. The scrutiny report prepared by the registrar of this court did not reveal any security breaches of the IEBC's RTS. IEBC successfully deployed a biometric voter register system which captures unique features of a voter's facial image, fingerprints, and civil data to register and update voter details across the country and also in the diaspora. The BVR captures a voter's facial image, fingerprints, and civil data, which features are unique to each of the voter. In compliance with Section 6A of the Elections Act 2011, IEBC opened the register of voters for verification of biometric data by members of the public for a period of 30 days. Thereafter, the register was revised to address issues arising from the verification exercise. KPMG then audited the register, and we are satisfied that the inconsistencies and inaccuracies identified during the audit were somewhat successfully addressed. The second issue was whether there was interference with the hap-rounding and transmission of Forms 34A from the polling station to the IEBC public portal. The first petitioner arranged staging that a person who had access to the RTS intercepted, detained, or stored Forms 34A temporarily to convert or manipulate it before uploading it on IEBC's public portal. It is arranged also on 11th August 2022 IMBC dumped over 11,000 forms 34A on the public portal between 11 to 11:09 hours. To rebut this allegation, IMBC and its chairperson, in their response dated 26 August 2022, denied staging and unauthorized intrusion of the RTS. In that regard, they urge that every image of Form 34A was uploaded immediately after the transmittal of results. The form was received as evidence by the timestamp. Similarly, the first respondent denied these allegations. Our finding: 1, no credible evidence was presented to prove that anyone accessed the RTS to intercept, detain, or store Forms 34A temporarily before they were uploaded to the public portal. The allegation that 11,000 Forms 34A were affected by staging was similarly not proved. 2, the allegation that IMBC, its officials and strangers used a tool to tamper with the Forms 34A before converting them to the portable document format, that is PDF, that eventually appeared on the public portal, was sufficiently explained when IMBC demonstrated how KIMS captured and transmitted the image of Form 34A. Accordingly, we dismiss that allegation. 3, during the ICT scrutiny, it turned out that the transmission logs produced in the affidavit of Justice Nyangaya were of no probative value. The registrar's report shows that the original Forms 34A from the contestant polling stations, which were allegedly intercepted, were exactly the same as those on the public portal, and the certified copies that were presented to this court pursuant to the provisions of Section 12 of this Supreme Court Act 2011. 4, regarding the allegation that the integrity of the public portal was compromised, this was disproved by evidence of consistent attributes such as unique timestamps, uniform PDF conversions at the polling stations, correct polling station mapping, and consistent KIMS reporting from verification to transmission of results. 6, the RTS was configured on a virtual platform network, VPN, and the SIM cards locked to a specific polling station. The server was also configured to accept results only from authorized and properly mapped KIMS kits. In our view, the petitioners failed to produce credible evidence to the contrary. 7, a review of some of the logs presented as evidence of staging showed that they were either from logs arising from the 2017 presidential election or were outright forgeries. In our considered view, there was no evidence of a man-in-the-middle server configured to the IMBC's VPN network, and no evidence was produced to show that the chairperson of IMBC and staff were part of the arranged conspiracy to stage the transmission process. 9, whether there was a difference between Forms 34A uploaded on the IMBC public portal and the Forms 34A received at the National Tallying Center, and Forms 34A issued to the agents at the polling stations. On this issue, the first petitioner's case was that there was deliberate manipulation and tampering with Forms 34A, as demonstrated in the affidavits, to the effect that votes were being deducted from the first petitioner and being added to the first respondent. To support this petition, evidence was contained in the affidavits of Honorable Martha Karua, sworn on 21st August 2022, Celestine Anyango Opio, Arnold Ochieng Oginga, and John Mark Githongo, which was sworn also on 21st August 2022, and a further affidavit sworn on 28th August 2022. Dr. Nyangasi also swore an affidavit on 21st August 2022, and so was Martin Papa, to support that allegation of handing and subtraction of votes. On the other hand, IEBC and its chairperson urged that all Forms 34A transmitted to IEBC portal were not interfered with or manipulated. Further, that the Forms 34A signed at the polling station and issued to the agents were identical to the Forms 34A uploaded on the public portal and delivered to the National Tallying Center at the Bomas. It was contended that in any event, IEBC used the original physical Forms 34A to tally, verify, and declare the presidential election results. This court ordered scrutiny of the forms from the 41 polling stations outlined in the affidavit of Celestine Opio to ascertain the allegation of interference. And this is our finding. 1, there were no significant differences captured between the Forms 34A uploaded on the public portal and the physical Forms 34A delivered to Bomas that would have affected the overall outcome of the presidential election. B, no credible evidence was presented to support the allegation that Forms 34A presented to agents differed from those uploaded to the public portal. The report by the registrar of this court confirmed the authenticity of the original forms in the sampled polling stations. The affidavits of Celestine Opio and Arnold Ochieng Oginga, while containing sensational information, were not credible, as the registrar's report confirmed that all the Forms 34A attached to those affidavits and purportedly given to them by the agents at select polling stations were significantly different from the originals, certified copies, and those on the public portal. The purported evidence of Celestine Opio and Arnold Oginga, sworn in their respective affidavits, are not only inadmissible, but are also unacceptable. It has been established that none of the agents on whose behalf the forms were being presented swore any affidavit, that there is nothing to show that they had instructed both Celestine and Arnold to act for them, yet the two have gone ahead to depone on matters that are not within their knowledge. This court cannot countenance this type of conduct on the part of counsel who are officers of the court. Though it is elementary learning, it bears repeating that affidavits filed in court must deal only with facts which an opponent can prove of his own knowledge, and as a general rule, counsel are not permitted to swear affidavits on behalf of their clients in contentious matters like the one before us, because they run the risk of unknowingly swearing to falsehood and may also be liable to cross-examination to prove the matters deponed. We must remind counsel who appear before this court, or indeed before any other court or tribunal, of the provisions of sections 113 and 114 of the Penal Code that swearing to falsehoods is a criminal offense, and 2, that it is an offense to present misleading or fabricated evidence in any judicial proceeding. Section 114 of the Penal Code states, and I quote, "Any person who swears falsely or makes a false affirmation or declaration before any person authorized to administer an oath or a declaration upon a matter of public concern, and at such circumstances that the false swearing or declaration, if committed in a judicial proceeding, would have amounted to perjury, is guilty of a misdemeanor." One of the most serious losses an advocate may ever suffer is the loss of trust by judges for a long time. Such conduct amounts to interference with the proper administration of justice. The contents of the affidavit of John Mark Githongo, which may contain forgeries, are also dismissed for not meeting the evidential threshold. Those averments contain no more than incredible and hearsay evidence. No admissible evidence was presented to prove the allegation that Forms 34A were fraudulently altered by a group situated in Karen under the direction of persons named in the affidavit and video clip attached to it. As a matter of fact, these two affidavits amount to double hearsay and incapable of being proved at each of the rears. We turn to Form 34A for Gacharaigo Primary School, which was sensationally presented by Madam Judy Soweto, advocate, to show that one Jose Camango accessed the RTS and interfered with the result contained therein. This also turned out to be no more than hot air, and we were taken on a wild goose chase that yielded nothing of probative value. The KIMS kit relating to Songonyo Primary School, which bore the same serial number with another, was admitted by IMBC as an inadvertent manufacturer's error. We are also satisfied that the two kits and other identifying features that were markedly different, including the timestamps and polling code, and therefore nothing turns on this anomaly. Therefore, to the question whether there was a difference between Forms 34A uploaded on the IBC public portal and those received at the National Tallying Center and those issued to the candidates' agents at the polling station, we have found none. Issue number 4, on whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui, Rural, Kachiriba, Rongai and Pokot South constituencies, and electoral ones in Nyaki West, in North Imenti constituency, and Kwanjenga in Embakasi South constituency, resulted in voter suppression to the detriment of the petitioners, and especially in petition number 5 of 2022. It is common knowledge that IMBC postponed elections for various seats during the general elections of 9th August 2022 due to mix-up of ballot papers in the above-named electoral units. It is the combined case of the first and second petitioners that, in terms of Articles 136, 2A, 177, 1, and 181, as read with Article 1, 1 of the Constitution, the chairperson of IEBC had no jurisdiction to postpone elections in those areas. That Section 55B of the Elections Act is inconsistent with the Constitution and therefore void to the extent that it purports to donate to IEBC power to postpone elections in the constituency, county, or ward, contrary to the Constitution, and the postponement undermined the conduct of free, fair, credible elections by depriving the voters an opportunity to vote for all the candidates on the dates stipulated by the Constitution. The petitioners further contend that the postponement of elections and the overall effect of suppressing voter turnout in the electoral units in question, which was prejudicial to him. Both the first and third petitioners also believe that elections were deliberately postponed in Kakamega and Mombasa counties. It was arranged that these areas are considered to be first petitioner strongholds, and as such, the postponement of elections worked to his disadvantage and handed that benefit to the second respondent. These assertions were denied by IEBC and its chairperson. They, however, admitted that they experienced confusion with the printed ballot papers and explained that they only discovered the mix-up on the eve of the election when the ballot papers were being distributed to the polling stations. That as a practice, ballot papers can only be opened on the eve of the election day to avoid any mischief, and that by the time the mix-up was discovered, it was logistically impossible to print and replace the ballot papers in time for the elections. For this claim to succeed, it must be demonstrated first IEBC and no authority in law to postpone the elections, and secondly, that the postponement was deliberate and calculated to suppress voter turnout so as to affect the result by reducing the petitioners' overall votes. We've looked at the provisions of Section 55B of the Elections Act, which provides for circumstances when elections can be postponed in a particular electoral unit, including in cases of emergency. We are therefore satisfied that on the basis of the foregoing provision, the third respondent and the requisite power to postpone election in the constituencies, counties, and wards in question. Concerning the allegation of voter suppression, we note that voter suppression is generally recognized as a political strategy which takes many forms, but whose practical effect is ultimately to reduce voting by deliberately discouraging or preventing targeted groups of people from exercising their right to vote, and thereby to influence the outcome of an election. It therefore goes against the letter and the spirit of Article 38, which guarantees every citizen the right to make political choices based on universal suffrage. As regards this allegation, it has not been shown that by postponing elections in the named electoral units, IEBC acted in bad faith or was influenced by irrelevant factors and considerations. From the explanation tendered, we are satisfied that the postponement was occasioned by a genuine mistake which in our view could have been avoided and the members and staff of IEBC been more diligent when they went to inspect the templates in Athens, Greece, where the printing of ballot papers was undertaken. In the absence of any empirical data, we cannot find a basis upon which to conclude, as a matter of fact or evidence, that the postponement affected voter turnout, as a consequence of which the first petitioner alone, as a presidential candidate, suffered disadvantage. At any rate, the nature of the ballot being an individual decision and secret, there may be other factors to which the turnout in the named units can be attributed. From the evidence on record, however, it appears to us that 2022 general election recorded one of the lowest turnouts since the introduction of multi-party political systems some 30 years ago. If there was a low voter turnout, it affected all the 6 categories of candidates, and its explanation, in our view, lies elsewhere, but certainly not a calculated suppression. On the other hand, in rebuttal to these claims, IEBC illustrated with examples to our satisfaction that there was no nexus between the postponement of elections and voter turnout in the affected units, far from the fact that this claim was undoubtedly just another red herring. It has nothing to do with the question under review, and accordingly we reject it and own that there is no proof that the postponement resulted in voter suppression to the detriment of the first petitioner. Whether there were unexplainable discrepancies between the votes cast for presidential candidates and other elective positions, issue number 5, the first petitioner was categorical that there was systemic ballot stuffing in certain counties, mainly in the Rift Valley and central parts of Kenya, where, according to him, a total of 33,208 votes were cast for president only, without corresponding votes for the other elective positions. On the part of IEBC and the chairperson, while acknowledging that indeed in some instances there was vote differential between those cast for president and for other positions, but maintained that they were insignificant and those instances related to votes by prisoners and citizens in the diaspora who only vote for the president but did not take part in other elective positions. The differential also includes rejected ballot papers and stray votes which do not count as valid votes. The well-established principle that the person who asserts a fact must prove it casts the burden upon the first petitioner to demonstrate that there were instances of ballot stuffing of such a magnitude as to justify the nullification of the presidential election. Ballot stuffing, which is an illegal addition of extra ballots, is a type of electoral fraud aimed at swinging the results of an election towards a particular direction. Not a single document has been presented by the first petitioner to prove systemic ballot stuffing. A figure of 33,208 votes relied on in this claim is based on unproven hypothesis that since the number of votes cast for the president is higher than those for other positions, then, without more, it must follow that there was fraud.